This heroic cop detained a guy for filming in public, but he had no clue he was about to get a legal smackdown.
Well, you can ask, but I'm not going to answer.
So to me, that's suspicious. So right now you're detained. Figure out what's going on. What are you doing?
You might want to get a sergeant before you do all that.
No, I don't have to. Why are you looking at
I'm requesting a supervisor right now.
Why are you looking at people's personal vehicles?
I don't answer questions, man. Am I suspected of committing a crime?
Yes.
Okay, so what crime?
Why are you looking at people's personal vehicles?
Again, man, I don't answer questions.
I'm telling you to answer this question. You're under investigation for
I
something.
don't answer questions. Is suspicion a crime?
What's your name?
What's going to happen if I don't give you my name?
Then you can be under arrest. Failure to identify, that's a crime, right?
But I will tell you that failure to identify is a secondary charge. If I've committed a crime, I'm required to provide my ID. No, you have no suspicion that I've committed a crime. Hopefully they get this figured out real quick. You got the clown squad out today.
All right, you have a beautiful day.
Is that right? No more threats, man? Show some more respect for the public next time.
Back, everybody. As many of you guys know, I'm a law enforcement trainer instructor. I train and instruct military and law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, advanced criminal investigations, etc. And in this video, we're going to be doing kind of just a breakdown of that video you just saw. And I'm going to, shameless plug here, I'm going to show you guys screenshots from my actual constitutional patrol tactics course. And we're going to be talking about reasonable articulable suspicion. And we're going to kind of be going into just some fundamentals. So this is a basic teaser into the courses that I teach, which are designated for, certified for law enforcement. But again, I open my training up to anybody that wants to go, because I think that law-abiding citizens should know the same things that officers know when it comes to the law. There should be no surprises, and there is no surprises, right? There's no secret laws out there. Constitutional case laws constitutional law is constitutional law. And so let me just kind of get this out of the way real quick. Just trigger warning: if you don't like cops, you're going to hate this video. You're going to be very upset. So there's a trigger warning. It's probably not even worth your time, because it's just going to make you mad. If you are interested in learning constitutional law, if you are interested in law, you are interested in learning, and you're an open-minded person, I think you're going to get a lot out of it. If you're law enforcement, I highly encourage you to watch it. I highly encourage you to save this, bookmark it, share it with your team, share it with your agency. If you have brand new cops, they need to watch this, because what I'm going to go over is going to be more than what they'll learn at any academy, any FTO process. Again, I'm just being honest with you. And even if you're a seasoned cop, you might get a tidbit or two. There might be some case laws that you've never heard of before. So, this is just a kind of a teaser plug for the courses that I teach. And again, we're just barely going to explore surface level of reasonable articulable suspicion. So the first thing that I kind of want to mention in this video, as we can see, you have an auditor, journalist, whatever you want to call them. You have somebody that's recording law enforcement, recording what he can see in public, on a public street, in a public right of way, in public property, whatever verbiage you want to do for being in the public and recording. And then he's contacted by law enforcement, and the law enforcement officer says, no, you are detained because you're suspicious, right? I'm conducting an investigation, therefore you must ID yourself. And that's kind of where everything starts. So let's talk about the case law. As you guys have seen on this channel so many times, it's only fitting that we talk about Brown v. Texas, 1979, right? The Supreme Court has affirmed that law enforcement needs reasonable articulable suspicion in order to detain and compel somebody to identify themselves. So you need what's called RAS, reasonable articulable suspicion of a crime, in order to detain somebody and then compel them to identify themselves. And so, as we see when it comes to not just individual contacts with citizens, but also traffic stops, for example, United States v. Cortez, the Supreme Court has affirmed, right, the standard for stopping, detaining, compelling identification is going to be, again, as we see in Texas v. Brown, reasonable articulable suspicion. So that tells us that reasonable articulable suspicion is important, right? It's important that we know and we understand what that is. It's important that we be able to articulate that. So we know what the case law says, you have to have it. So what is it? Well, let's take a look. What is reasonable articulable suspicion? So reasonable suspicion is a legal standard that falls between mere speculation or hunch and probable cause being the higher standard. It's a subjective assessment made by the observer, you as law enforcement, that is based on specific articulable facts and reasonable inferences that are drawn from those facts. These facts may lead an observer to suspect that an individual is, has been, or is about to be involved in criminal activity. So we got the dictionary case law definition down. But again, what does that mean? Because I will tell you, when I FTO, when I teach new people, when I'm doing for example, the advanced criminal investigations, when I'm teaching people about probable cause, when I'm teaching just cops how to be cops, right? It's really important that we understand how this translates into actual policing, right? Because there is a disconnect, and for some, trying to understand this, it can be confusing. And so, with that in mind, we have to train our new people. We have to train our law enforcement to understand that we need facts, observations, and inferences that would lead a reasonable person to believe that a crime is occurring, has occurred, or is about to occur, right? And so what a lot of cops just automatically think, and the words that come out of our mouth are just, you're being suspicious, right? That's suspicious. Or somebody calls something in of being suspicious, right? So we get this basic word, suspicious, that doesn't mean anything, right? From a case law perspective, it means nothing. So why do I use it? I shouldn't. And so I have trained myself. I don't use the word suspicious. I don't like it. I am not going to use suspicious when talking to another officer. I'm not going to use suspicious in my report. That word is not applicable to me when I'm doing business. Now, a lot of people may think that's extreme. Whatever. When I have a person that's riding the car with me, or again, when I'm training, I tell them, don't say suspicious. I don't want to hear suspicious. If you say suspicious, it means absolutely nothing. Because suspicious, again, is not a misdemeanor. It's not a felony. It's not an infraction. So why use a word you can't use? So if you see something and you want to think suspicious, okay, stop. Don't say it. Describe what that person's doing. Describe what that person's doing. Now, that may sound silly, but when you describe what they're doing, it's going to lead you to a decision. It's going to lead you to a point, a T in the road, whether you have reasonable articulable suspicion or you don't. And what's great is we have great case law that 100% affirms when we can and when we can't take action. So, one case law that a lot of people are unaware of that establishes reasonable articulable suspicion, as you can see here on your screen, Illinois versus Wardrow, 2000. So, an officer had just three elements, right? He had an individual's presence in a high crime area, one, an individual's unprovoked flight when they saw law enforcement, and then when they caught up with them, they saw an individual's nervous, evasive behavior. So based upon unprovoked flight, nervous, evasive behavior, and being in a high crime area, the United States Supreme Court said officers had reasonable articulable suspicion. So as you can see, this standard is not very high. There's no reason why cops should be violating people's rights. Absolutely zero reason, right? And so a smart cop that knows case law can be like, hey, I had reasonable articulable suspicion. Well, why? You were in a high crime area? You ran, as soon as you saw me, you ran away, and you're being very evasive, and you're being very nervous, therefore, I have reasonable articulable suspicion. No, you don't. It doesn't matter what that person thinks, right? And this is why I say people that don't like cops are going to hate this video. It doesn't matter. At that point, it's of no consequence, because what am I going to reference? I'm just going to reference United States Supreme Court case precedents, Illinois versus Wardrow, 2000, and your opinion is no longer, it doesn't mean anything to me. It's of no consequence because the Supreme Court has said, no, those three factors do equate to reasonable articulable suspicion. Cool, you don't want to give me your ID? Easy obstruction charge ever. I don't have to get emotional about it. I don't have to get excited about it. I can just say, hey, I have reasonable articulable suspicion. United States Supreme Court affirmed, pursuant to, in accordance with Illinois v. Wardrow, that I have reasonable articulable suspicion. Therefore, you are detained. I am compelling you to identify themselves. I'm going to ask you a bunch of times for your ID, and then once I've made my arrest decision, you're going to be taken to custody for obstruction. In my report, I'm going to quote United States Supreme Court case precedents. I'm going to show on my body camera that I explain United States Supreme Court case precedents to you. I repeatedly asked you for your identification. I asked you for your identification 20 times in sequence, numerically, to which you told me to pound sand, so I arrested you. Good luck having your attorney beat that one. And we're just one case law in, guys. There's a few of them here. Good luck, bro. Again, and those are the cases that I want. That's what I teach law enforcement. That's where I want law enforcement to go. I want law enforcement to be so smart, to be so intelligent, to understand the case law, that they're spewing case law to their defendants, to their suspects, explaining to them what they're going to do, and then following through with it. Again, I'm all about good policing. And good policing, when you have a cop that knows case law, when you have a cop that's smart, they can do a lot of good. And again, you can be upset with me, and I know that people that don't like law enforcement are looking at this, and I know the comment section is going to be filled with people upset. But your opinion's of no consequence because the United States Supreme Court has already affirmed their decision. Again, it's there. 3 things. Cool, I get it. You don't agree. You don't have to agree. So again, I'm going to show in my report and on body camera that I was nice to you. I asked you for it 20 times, even though I've established that I have RAS. You said no, easy obstruction charge ever. Again, hire your attorney. Cool. Have your attorney explain this to you. You can pay good money for them to explain it to you. And I'm sure they will. So there's that one. Here's another one that I want to bring up. This is one straight from the 10th Circuit. This is a driving one. Here's another elements of RAS, facts and observations to prolong a stop, right? Reasonable articulable suspicion, right? So this would be something that you could detain somebody longer in a car in order to get a drug dog, right? So this is United States versus whatever this long name is. Again, 10th Circuit case. These were the elements that an officer had and held a car for. The use of air fresheners to mask the odor of illegal substances from an officer or a canine. So, air fresheners. So, element number 1, air fresheners. Number 2, possessions of multiple cell phones. Number 3, driver was overly nervous, gripping steering wheel, cracked voice, trembling hands. 4, inconsistent, vague, implausible driving plans. And then 5, provided inconsistent, contradictory statements. That's all the officer needed in order to hold the car on a traffic stop for over an hour until a police canine could come. And obviously they alerted, they found narcotics, and the only reason why this is even a case law is because it was appealed, right? So obviously he was charged with a crime, and then they tried to appeal it. The 10th Circuit, no, the officer had reasonable articulable suspicion. The 10th Circuit said all these things are elements of reasonable articulable suspicion. And now you're looking at that and like, having air fresheners is 100% legal. It is. Possessing multiple phones is absolutely legal. It is. Gripping a steering wheel, being nervous is legal. It is. Lying is legal. It is. Contradicting yourself is legal. It is. All those things are legal. There's nothing illegal about any of those. But again, the 10th Circuit upheld that. Combine those together. Yeah. Officer has reasonable articulable suspicion. Again, you may not like it, and I understand you don't like it, but it's the law of the land, right? That's 10th Circuit case precedents. Reasonable articulable suspicion. Let's look at another one. I know this is a good one right here. The 7 factors, right? So this is United States versus Jordan. Again, 6th Circuit, 2024. I think this is a good one. I like this one because it's just people just they can't believe it. So the appellate court held the trooper had reasonable suspicion to extend the stop, again, based upon the totality of circumstances. We know Illinois v. Gates establishes totality of circumstances of several factors. These include Sanders. So Sanders was the guy that was stopped. Suspicions, travel plans, right? So the length of time Jordan had been traveling, the guy, Jordan's implausible explanation for her travel plans, Jordan's plans to extend the rental car agreement, Jordan's heavy breathing, right? The court observed that 3 facts placed Sanders and Jordan within the drug courier profile previously recognized by the court. Under 1, the 3-day rental from Florida, a common drug source state, driving long distance when flying would have made more sense than driving through the night. So let's just, again, I can't make this up. Look it up yourself. Nothing illegal with how long you drive. Nothing illegal with extending your rental car agreement. Nothing illegal about heavy breathing. Nothing illegal about having a 3-day rental from Florida, right? Nothing wrong with renting a car from Florida. Nothing wrong with driving long distances when flying would be more efficient. And there's nothing illegal or wrong with driving through the night. But guess what? That gave law enforcement reasonable articulable suspicion. Again, Cannot make this up. So I know a lot of you guys are probably looking at this and, I'm sure you guys are, I know a lot of people are looking at this. They're like, there's just no way. But again, the United States Supreme Court has affirmed and upheld that absolutely are factors and elements of reasonable articulable suspicion. And again, why that matters and why that's important is because as an officer, law enforcement is allowed to utilize these elements, of which are not criminal in and of themselves, to again detain, hold, reasonable articulable suspicion, compel ID. Here's another one. This is the last one we'll look at. Ninth Circuit Court of Appeals, United States v. Burleson, 2020. Elements of reasonable articulable suspicion, facts and observations to conduct an investigatory stop. Right. So suspect being in a designated high crime zone late at night. Suspect appearing lost and avoiding lighted areas. Suspect observing a couple until he saw the officers at which he to which he walked away. At that point, he walked away. Suspect taking flight after an officer called out to him. Suspect continuously holding his right hand near his front waistband before and during the chase. So, literally, like what one could consider holding his pants up as he's running. Again, the Ninth Circuit, Court of Appeals, Ninth Circuit, United States v. Burleson, 2020, stated that the officers had reasonable articulable suspicion. So again, I ask officers, again, back to what we were talking about. Don't say suspicious, describe it. Well, we're driving around, so let's say we're driving around a casino, we're driving around someplace that's known to be a high crime area. Okay, we got one. I see somebody and they look at the police car and they look away. They're trying not to show their face. They're kind of walking through in and out other buildings, out structures, just trying to get away from us. Okay. So don't say suspicious, say those elements, because then we can take these elements and be like, well, this element came from United States v. Burleson. This element came from Illinois versus Woodrow. This element came from the 10th Circuit, United States versus Comestiki, whatever that case law was, right? So you're taking elements and you're combining them into what the courts want you to do. You're forming reasonable inferences based upon facts and observations. That's all you're doing. So the more case law you know, the easier it is to formulate these and say, no, I absolutely have reasonable articulable suspicion. This is why. I'm not stopping you because you're suspicious. I'm stopping you because you did this, and this, which gives me reasonable articulable suspicion. Well, that's not illegal. That's fine. The court has made it very clear it's not illegal to do all these things. But when you do these things together, that forms an inference to me of criminality. So therefore, you're not free to go. And also, I need your ID. And if you don't want to give me your ID, that's fine. I'm going to call a backup officer or 2 or 3, and I'm going to ask you numerically, repeatedly, to show me your identification, to present your identification. Once you say no 20 or 25 times, I'm going to go ahead and arrest you. Or go ahead. You're right. Invoke your Fifth Amendment. Great. You invoked your Fifth Amendment unambiguously. Doesn't take away from my reasonable articulable suspicion. Perfect. Now you're being arrested for obstruction. Again, you can invoke your Fifth Amendment. I don't care. You can tell me no. I don't care. You can do my favorite. You can ask for your supervisor. Again, I don't care. You're still going to jail. And here's what's great about the supervisor thing. Again, can a driver or can a bystander prolong their own stop? Sure. How do people prolong their stops all the time? Can I look for my insurance card? Can I look for my registration? Can I check my email? I want to speak with your supervisor. Can I call my mom, husband, friend? And I usually ask officers, as you can see here, what have you seen people do? So if you want to prolong your own stop, okay, you're just giving the officer more time to continue on in his investigation. I want to speak to a supervisor. Cool. You said it, not me. You're prolonging your own stop, not me. So again, this is just very basic. Again, not even scratching the surface of reasonable articulable suspicion. But again, this is what I teach law enforcement, and this is what law enforcement needs to be better at. Because here's the thing: at the end of the day, let me leave you with this. I totally understand this, and this is not lost upon me. There are people out there that do not want law enforcement at all. They feel like there's no need for law enforcement. There's no need for law enforcement to be around. I completely get that. That's fine. Doesn't change the fact that law enforcement is reality in this country. And so I understand that no matter what evidence I may have, because I've been there, I could have somebody dead to rights and they're going to tell me that I don't have reasonable articulable suspicion or I don't have probable cause. I can't tell you how many times I've executed a warrant on somebody's house, phone, on their person, and they tell me I don't have the right, I can't, all the time. So people are always going to tell me, no matter how much evidence I have, that I don't have a right to do what I'm going to do. That's fine. And again, that's of no consequence to me. And so just realize that no matter what you do, people are not going to be happy. And they're not just going to willingly give you what you ask for, even if you have all the knowledge, even if you have reasonable articulable suspicion or probable cause. So, being that what it is, if you know the case law, if you can articulate it, if you can point to it, if you can cite it, you can use it. It's yours. Nobody can take that from you. And you can rest assured knowing anytime you place cuffs on somebody, anytime you detain somebody, there's nothing they can do about it. There's no recourse they can go after you. They can't come after you because you've operated within the realm of Supreme Court, Circuit Court case precedents. Their opinions of no consequence because you are smart, you care about constitutional rights, you care about doing the job right, therefore you learned the case law. That's why whenever I go and make contact, again, I make contact with people. Again, I'm still actively in law enforcement. I still actively go out, and when I investigate, I will undoubtedly get probable cause to make an arrest. And people are going to say, I did nothing wrong, you're wrong. That's fine. You can get my report. Your attorney will get my report. Best of luck to you. Because I'm not here by accident. I wish you the best. When you have that kind of knowledge and you have that kind of confidence to do the job, you're going to undoubtedly de-escalate situations. You're not going to be emotional about it, and you're going to make good calls because you are abiding by case law, case precedents. So there you have it. Again, this is just a very, not even scratching the surface, but hopefully you can see that reasonable articulable suspicion is not a high threshold. It's really not. It's very easy to not violate people's rights. Very easy. It's also easy to violate the rights if you just refuse to educate yourself and get better. So again, hope this video was helpful for you guys. Let me know what you think in the comment section below. Are any of you guys surprised by this case law? Did any of you guys realize that reasonable articulable suspicion was this easy? Tell me what you like. Tell me what you don't like. Can't wait to hear from you in the comment section below. As always, guys, long live the Republic.